Well, why don't we go ahead and get started? Welcome, everybody. My name is Michelle. I'm with the Meridian Library Outreach Services. I'd like to welcome you here this evening. Mark Wight will be our presenter tonight, Files for Life, Powers of Attorney. And would like to welcome you while you are muted, as well as your video is off. This meeting is being recorded, so for your privacy, keep that in mind as well. If you have questions, please use the chat. You're welcome to chat me directly, MLD Programs, or everybody, and I will interject for Mark periodically if there are questions along the way. With that, I'll turn it over to Mark.
Very good, thanks. Welcome everybody. I know some of you were with us. It doesn't seem like it was a month ago. But as my kids keep telling me as I talk to them across the country, time has no meaning anymore. I'm sure there's a lawyer joke in that too about time and meaning and all that. But thanks for joining us. Ask your questions. I love this to be interactive. If you've got questions, hit the chat. Text us in a little message. If I don't take it right away, don't worry, we'll get to it at some point, or at least I'll try to do that. So in getting started, a couple of things to keep in mind. First of all, Mark Wight from Idaho Estate Planning, and that's what we do is estate planning. And if you were with us last time, we tried to explain that estate doesn't mean what we tend to always think that it means. Estate is a legal term which means anything that you own at your death. And so planning for an estate or doing estate planning is planning for your people and your stuff. And I kind of coined that people stuff planning. Tonight, we're not talking about at your death. We're going to talk about how to enable and empower people to make some decisions for you, take care of things for you if you became incapacitated. So we're talking about powers of attorney. We're going to talk about a couple of different kinds of powers of attorney. And so hang with me as we we're going to have three parts to this. We're really going to talk about three different parts of estate planning, or of powers of attorney. The first one is really probably what you were thinking when you got on, okay? It's the thing you were thinking, hey, I want to find out about powers of attorney, what does that mean, et cetera, et cetera. The second portion of this is a little follow-up, and when I get there, you'll go, oh yeah, I know why you're talking about this. And then there's a third part, if you're stalwart and you hang in there, going to talk a little bit about why you might want to do your own planning instead of, doing what we call the default planning that so many people do. If you stay for the first part and that's good enough for you, and you check out, wave or on the chat line, just say thanks, that was awesome. No, I mean it, say it was awesome, that'll help me. And then we won't look for you after that. If you want to hang around for more information, you're certainly welcome to hang around. If you were here just before we got going, I was telling Michelle there'll be some brownies and coffee when we get done. And I hope you have brownies and coffee, because this is the best we're going to do in the age of COVID. So let me get started. Powers of attorney. First thing is, what is a power of attorney? Very short discussion is it's a legal document. And in the legal document, myself, I'm giving someone else power or authority, however you want to look at it, to act on my behalf should I become incapacitated. Now in Idaho, incapacitated means that I lack the ability to make sound decisions for myself. And so I've been involved with this for over 30 years. I've seen in front of a judge where we had a doctor that wrote up a report and said, well, John Brown, Your Honor, is not making good decisions, but he has the ability to make those good decisions. And so the judge says, okay, he's not incapacitated. That's a subtle distinction, but you got to know that. So if I'm giving someone else the authority, it's because when I'm here and I can make the decision, I'm choosing somebody to do that, so that at some point, if I can't make decisions, they step in and make those decisions for me. And so we talk about powers of attorney in the terms of medical needs and financial dealings. Oh, sorry, went the wrong way. I know what I'm doing, I really do. So we have a couple of things. We have a general power of attorney, we have a specific power of attorney. Now, that didn't change over here, did it?
No.
So I apologize, everybody, hang on. It's supposed to be doing this.
Technical difficulties. There we go.
There we go. I don't know if you can see me, I'm just telling you I'm smarter than I look. All right. So a general power of attorney versus a specific power of attorney. When we say general, we mean something that's it's pretty general, meaning I give, let's say my wife, authority to act on my behalf as a general power of attorney. Well, that means that she can do a ton of stuff on my behalf. And it's not particularly limited. And so, and that's typically what we do. We grab a broad power of attorney. When we do a specific power of attorney, we're going to delineate certain acts that we want this person to do. Some of you may have been involved with this. Let's say that you're buying or selling a house, and you or your spouse or the co-owner aren't in town on that particular day. So I could give to my wife the specific power of attorney to sign the closing documents on my behalf. Can do that. That's a very specific power of attorney. Boy, I can't think of much else. I could give a specific power of attorney to manage my checking account. I could do a specific power of attorney to manage a business. Oh, that one's a little bit interesting because a business takes a whole bunch of stuff that needs to happen to make that work. So I don't know if that would be the right one to choose on that. So broad versus very specific. Durable powers versus non-durable. Now, what we mean by durable, really the only thing that we mean by a durable power of attorney is that it survives my incapacity. Okay, so I draft it up now while I have the cognitive ability to do that, and then I become incapacitated. That power of attorney is still good. If it's not a durable power of attorney, then if I become incapacitated, that power of attorney ends. I will be really, really honest with you. I don't know why you would do that. When we do estate planning anyway, generally we want that coverage. If something happened to me, then I've got the coverage so that somebody can make those determinations. They can take certain actions, even if I'm no longer competent to do that. So durable power of attorney is what most people do in their estate planning. So if we have a durable that survives my incapacity, I also have the ability to have what's called an immediate power of attorney. So what's immediate mean? It means that I'm signing and I'm giving my wife my power of attorney right now. So that's immediate, meaning it becomes effective at this very moment. Most people don't do that. Most people do what we call a springing power. Okay, it's an interesting term, but if you think about it, what that means is that down the road, something happens. I become incapacitated. And I set up a way to determine that I've become incapacitated. At that moment, then, that power of attorney becomes effective. So it would be most people don't use the term springing. It's a good term in the legal profession that we understand that. Again, it's kind of a shorthand way of saying that. So most people in their estate planning, springing power, durable for financial. And then what does that mean? What can I do with a power of attorney, a financial power of attorney? Well, a financial power of attorney is kind of, kind of self-descriptive there. I can manage somebody's finances. I can deposit checks. I can receive them. Now, okay, I just showed my age, and you're probably with me. People don't really deposit checks anymore. I still go over to the bank. I ran out deposit slip, and I send it over in the thing. There's a certain generation that doesn't do that anymore, and you're probably more sophisticated than I am. You take a picture of it and deposit it that way. Well, with a power of attorney, that allows me to go to the bank and say, I'm now the power of attorney. And if the bank is on board, then they have you sign some documents. And then you're the one that can make that happen. You can do the online banking. You can do the deposits. You can pay the bills. An important one is to arrange for a living situation. For example, if we get to the point where we need assisted living, who's going to sign the contract? Who's going to make that work? If I'm incapacitated, I can't do that. I'm not the one that's able to sign that. But my power of attorney, my durable, springing, financial power of attorney could do that for me. Buy and sell real estate on my behalf. We had a couple of the grandkids for a little over a week. Well, my daughter wrote out a power of attorney, a little different one, power of attorney that if something happened, we could take the kids to the doctor, or down to the hospital and say, yeah, we have authority to be making these decisions on their behalf. I've seen them with a power of attorney manage a business, fire people, you could sell the business, those types of things. So those are some of the different things that an agent could do. And so we have the power of attorney, we have the principal, we have the agent. I'm creating the power of the attorney, I'm the principal, and the person that I've appointed is the agent. Couple of technical things here to keep in mind. How do you create a power of attorney? Well, it has to be in writing. And it has to be signed by the person making it, that's the principal. And then it better state the powers granted to the agent. You can do a kind of a blanket thing. There's some interesting things, though, that really need to be specified in there. For example, some of the larger estates, they want to do some estate tax planning and gift planning. Well, if they want to make gifts, then they better specify that. And if one of the kids is the agent making those gifts, then if you don't specify it, then he can't make a gift to himself under state law. He can't do that, or she can't do that. So if you want them to be able to do that, you have to specify that. So it's got to be in writing, signed, state the powers, and it's got to be notarized.
Raylene had a question for you, Mark.
Okay.
For a specific power of attorney, does a person need a lawyer, or can they write it up themselves?
Well, the answer is you can do it. You can do it yourself. It's just that there are some challenges, and I've run into some really interesting situations when people tried to do it themselves. So let's say that you were doing something for the kids. Could you write that up yourself? Yeah, you could do that. If you wanted the kids to receive a deposit and put it in the bank for you while you were gone, you could probably do that. But like I was talking about, if you get into the little bit more complicated, you could do it yourself. But again, if you don't know what you're doing, you could run into some issues. A recommendation is that you work with somebody that's done it and knows all the legalities. partly just to help you understand what the upside and the downside is. So the recommendation, the first answer, the quick answer is no, you could do it yourself. The longer answer is I'm not sure that's the best idea. Okay, so keep that in mind as we do this. All right, so can just anybody do a power of attorney? So I'm getting a phone call because I'm at the home office and my phone talks to me while we do this. All right, sorry. So can anybody write up a power of attorney or execute one? And the answer is not just anybody. First of all, you've got to be 18 years of age or older, because under our statutes, that's the age of majority, or that you're an adult. 2, you have to have the cognitive ability to understand your choices and how they affect other people and yourself as well. And then the third one, just to keep in mind, is that if a court has determined you incapacitated, then you can't do a power of attorney anymore. And this is really a pain. And you'll see if you hang around for the third section of what I'm talking about, but it would be easier for you overall, cheaper, easier on your family if you would sit down and do up your powers of attorney now rather than waiting until later. One of the things that we've seen, especially with this COVID situation, is a lot of people, I'm not saying you, but a lot of people wait until something happens, something unexpected. It happened and now they're concerned, right? Well, I better have a power of attorney or my will or whatever in place. Well, if they're in the hospital, we can arrange that. We can make that happen. We can get something signed. Not right now. Can't. They won't let us in the hospital. So if you were putting this off and all of a sudden you're in the hospital and you're going, whoa, I better get that done now. Right now, it's too late. There was a time when even if you were in the hospital, it wasn't too late. But if other things happened, it could be too late. If you are in assisted living, we've been able to make some things happen. Visiting with a friend of mine who's a administrator at a skilled nursing facility, he says, no, you're not coming in. That isn't going to happen right now. So if you're incapacitated, you can't do it. There's some other options. You're not going to like them, but we'll talk about that. So the sooner, the better if you can put this together. I'm just telling you right now. All right, so let's say that you did up a power of attorney. You got it just right. You got what you wanted in there. It's working, or it will work. But what if you change your mind? Not so much you change your mind that I don't need a power of attorney. That we all should have a power of attorney, just in case. But what if we don't like the person we chose as our agent, the person that's going to act on our behalf? We see this fairly often, where maybe the one of our children that we had as that backup power of attorney, what if there's a falling out? What if there's been something happen to them and they're just not able to do it? What if they're off in outer Slobovia doing some missionary work, and it would just not work well for them to be the power of attorney? How do we make a change, or how do we get rid of it? Couple of things. And I put up there on the slide, it's a little easier to get rid of than it is to make one in the first place. First thing, you can just destroy the document. You can burn it. That seems a little much, but you can rip it in half. You can write across on the pages and write revoked and line through it. Probably ought to do that over your signature as well. You can create a new power of attorney. And in that power of attorney, which is what we do whenever we do a power of attorney and whenever we do a will, we say, by signing this, I revoke any previous power of attorney or any previous will. Just to make sure that there's no confusion, that we've got it all worked out. So that's one way to do this, is create the new one and say, I got rid of this one, gets rid of the previous one, or any other one. Now, there's a challenge, just to kind of give you a heads up, that if you've handed out a power of attorney to some people, and you want to change that version of the power of attorney now, you really should track down all those people that you gave the power of attorney to. And what I mean by this is not that you made them the agent, but that you gave them a physical copy of the power of attorney. You should really track that down and say, no, I changed it. Here it is. I've changed it. You need the new one. You need the new one, because they have the ability to rely on the old one, which you may not like. So one, be careful with what you do with the power of attorney. And if you're going to revoke it, if you're going to get rid of it, you have to let people know that's what you're doing. So this one is kind of a dicey question. Well, it's a dicey issue. I don't know if the question's all that dicey. It might not be a great question, but how do I know that my agent that I so carefully chose, or I didn't think I had a better choice, how do I know that they're going to do what I want them to do? Well, to a certain extent, I guess you don't. But if you have that question in the first place, that you don't trust them, don't make them your power of attorney. Just don't do it. Don't let that happen. Make sure you're very comfortable with the person you're choosing to do this. So that's the first thing. Second thing is, under our state law, in the Idaho Code, the agent or the power of attorney has a legal obligation to do what's in your best interest, the best interest of the principal. And they can't just use the powers to benefit themselves or take advantage of you as the principal. So that's good to know, that under law, they're not supposed to do that. Again, that may not be as comforting as you'd like it to be. The third thing to keep in mind is that violation of a fiduciary duty could be a crime, especially if they go and clean out your bank account. Okay, so you give somebody the power of attorney, and now they can go down and they can sign on the account, and they decide to just take everything out of there. Well, that's illegal, and that could be a crime. I can tell you that it is also that your estate or your kids or somebody else representing you can sue that person in civil court. And I can tell you that the judges in Idaho take a very dim view of somebody taking advantage of a person who's put them in this responsible position. So if you're a fiduciary and you're just going to borrow some money from the guy that appointed you as the power of attorney, don't do it. Just don't do it. If you want them to be able to do that, then counsel with an attorney, write up that power of attorney very specifically so they can do that. But understand that if somebody violates this, they're in trouble, but it happens after the fact, and now we've got to go chase them down. So please, in the first place, let's make sure you got somebody that you are very comfortable with doing this. Okay, so that was pretty quick. I went over a whole bunch of stuff that we could have spent another hour and some on the general, durable, financial power of attorney. Okay, so it's fairly general. It's durable, and it applied to financial things. Well, let's take a little different tour here for just a second. Let's talk about the healthcare power of attorney. Now, the power of attorney part is very similar. And what do I mean by that? Well, what I mean is we're still empowering somebody, making an assignment, authorizing somebody to do something on our behalf. That's a power of attorney. In this case, we're talking about healthcare decisions. So let's say that I'm in an accident and I'm unconscious, and the doctor needs to make some decisions about my care. But there's some options about what's going to happen, or what he could do or she could do, to get me through this situation. Well, if I don't authorize somebody, then either the doctor has to make his or her best guess and move forward, or if it's not urgent, then they could, maybe get over to court and get the judge to make some decisions on our behalf. Or I could have in place a healthcare power of attorney. Similar thing. Who can do one? Got to be 18 and over. You got to understand what's going on, because we want to do it now while we understand, in case something happens later and we don't understand, or let's say that we're just, unconscious and can't communicate what we want to have happen. So that's the healthcare. So this will be handed to a doc. We're going to hand it to the hospital people, anybody that's providing care for us. The agent, the healthcare agent, has a responsibility to make the decision that I would make. So recommendation every time one of our clients signs one of these is they sit down with the person they've chosen, which is typically a spouse and then the kids, and have the conversation. The conversation is, here's what I'm thinking. If we have a healthcare power of attorney, we may avoid the need for a guardianship. Going to talk about that in our third section. Something to keep in mind, most of you are familiar with the HIPAA authorization. It's the Health Insurance Portability and Accountability Act, and that imposed some restrictions on medical care professionals about providing your personal information to other people. The history of that was doctors gathering or hospitals gathering a lot of information and providing those over to, let's say, pharmaceutical companies as they do their studies and they're doing their research. And somebody said, well, we don't really want them to do that. When they passed it, though, they didn't limit it to those situations. It's a broad restriction. My doctor cannot give my information to just anyone. I have to provide them with the waiver or the permission to share my information. So why am I saying this? Well, one, because I'm an attorney and I like to talk. Two, you run into a situation, and we've seen this, where somebody's appointed a friend or somebody to be the healthcare power of attorney, but didn't give the doctors the permission to share information with them. Well, this is not a good situation. Been able to work through that, probably would for the most part, but I could see a situation where you've authorized somebody out of town. Maybe it's a sibling or an in-law or one of your children that lives out of town. And let's say they don't have the same last name. They show up and say, hey, doc, I'm the healthcare power of attorney. And the doc goes, yeah, I don't care. You have a HIPAA. So we just recommend very strongly that you be consistent, and in the HIPAA you list the healthcare power of attorney and also the financial power of attorney, because the financial power of attorney may need information from a doctor as well, not because they'll be making the healthcare decisions, but in order to make certain financial decisions, they may need to talk to a doctor and understand, well, is this a temporary thing? How much time are you thinking? Because we've got this thing coming up, and am I going to have to exercise my responsibilities as the power of attorney? Or is the principal going to be out of the hospital by then, or be able to manage this? And so we like to put both the financial power of attorney and the healthcare power of attorney on the on the HIPAA form so that they have that ability to get information from the doctors. With a healthcare power of attorney, we tend to make that durable, meaning that it lasts if they're not able to tell us or if they are cognitively unable to understand what's going on. And we tend to just make it immediate because, man, if there's a situation where we need somebody to step in a hurry, it's usually in one of these healthcare situations. Along with the healthcare power of attorney, and there is a state form. The state has designed a form. It meets the requirements of the Idaho statute. So you can actually find a form in the code book, or you can go online to the Secretary of State's website, and you can get what they call an advance directive or a healthcare power of attorney, and it'll have a form healthcare power of attorney, and it will have a form of the living will. Now, for whatever reason, our state legislature came up with the term living will, which is not really the most logical name that you could come up with. And why do I say that? Well, because a living will is more about instructions to let me die or instructions on how to let me die than it is about living. And a will doesn't do anything until you're dead, so the name is garbled up and it doesn't really mean much. If you think of it in terms of instructions to let me go, then that makes more sense. So when you are in a persistent vegetative state, so if we have the screen and it's measuring brain activity and there isn't any, the vegetative state, and it is persistent or permanent, or if we are terminal, it's a terminal situation, and the only way that I'm alive is by being plugged into some of that fancy machinery, and I'm unable to express my desires, what it is that I want to have happen, then this living will can be presented to the docs. Again, this would be the healthcare power of attorney, hands the living will to the doctor and says that Mark wanted you to do this. And then your wishes can be honored. So what are the wishes that you can have honored? Well, you can say, I want everything. I want you to plug me in, keep my heart beating, keep my lungs working, keep my kidneys working, everything. You can say, well, I don't want everything, but I want food and water. I want food or I want water. Or you can say, no, I don't want anything. Just let me go. So in explaining this to clients, I talk about everything, nothing, somewhere in between. Okay, I want everything, I want nothing, somewhere in between. You may find this interesting, but in my 35 years, I don't think I've had 5 people choose the first one and say, I want everything. It's just interesting. That's maybe kind of where we live. Maybe it's there's some religious issues involved, but I don't think more than 5 people have ever chosen that. 97% have chosen to just let me go. And then a few folks have chosen the in-between, give me food or water, or give me food and water for so many days, and then let me go. So that's the living will. Now, even if I choose one of those 3 levels, pain management is always included. So they will try to keep you comfortable. And so you say, well, listen, I don't want them to give me food or water. How do they keep me comfortable? Well, you'll get thirsty, I suppose, but at that point in time, you won't know. Your family might know that that's what's going on, but you won't. But they will do ice chips, maybe keep your mouth moistened. There'll be some pain meds. The idea is to keep you comfortable. And then, if you've chosen to just, it's time to go home, then that's what they'll do. So there's an issue that I have when people are trying to decide who they should choose as their healthcare power of attorney or their healthcare agent.
Mark, quick question.
Yes, certainly.
Back on the previous screen, I think this is, you had imminent underlined.
Yes.
Want to clarify the difference between that and, for example, in the current COVID situation where somebody might be on a ventilator?
Okay, so to be effective with a living will right now, to be an effective living will, it will not go into effect if, one, you can state your preference. If you can tell us, we're not going to follow the living will. So it's only if you can't communicate that to us. Second, if two doctors having personally examined you and have determined that your death is gonna happen, it's imminent, it's within a short period of time, if you are disconnected from your, from all of that fancy equipment that they have at the hospital, if you're connected to that, they're just gonna say, well, you would die if we disconnected you. There's not a good chance. In fact, there's a very slight chance of you coming back from this because your situation is terminal. So if death is imminent, and that's what I mean. So if I'm connected to, say, a ventilator, and two doctors have come in and they said, yeah, you got a ventilator, so what? Your brain is working fine. Your other organs are functioning fine. Your lungs just not getting enough oxygen. Well, that's what we can do. We can make sure that your lungs are getting enough oxygen and we can oxygenate the body. I can't tell you that if we disconnect you right now, you're gonna die. But you have a much better chance of recovering or a better recovery if we can keep you oxygenated. So that may sound subtle, but it's not for most doctors. If they walked in and you're ventilated, but there's no brain activity, that's not a terribly difficult case for them to say, death is imminent. If we are in if we're in a situation that's deteriorating and it's deteriorating rapidly, so that whether you're connected to the ventilator or not, boy, you're just gonna go. That one's not a terribly hard one either. But if we walk in, you're on a ventilator, please don't be on a ventilator. Everything that I read and understand about it, you're not gonna enjoy this. This is not gonna be good. But if everybody understands that this looks like it's going to be a temporary thing and that you're going to be with us, that's not imminent. That is not death is imminent. We are not expecting you to die. Does that help? Did that answer that question?
I believe so. Thank you.
I'm looking at the screen and seeing myself, and so I'm answering it going, okay, yeah, that answered it. So I hope that answered your question. So yeah, and that in the time of COVID, things are a little bit different. So I appreciate that. It's a good question. I was going to start there's an interesting issue for me when it comes to choosing the appropriate agent or healthcare power of attorney. For example, it can be a very tough decision to pull the plug on mom or dad, to make that decision and tell the doc that, well, this is what mom wanted to do. It's if she meets those criteria, she's going to die. We should just, withdraw the life support. That can be very difficult. It is not a good thing to do to some people to have them making that particular decision. So a suggestion is you need to decide what it is that you want to do. And then I think it would be very helpful for you to decide or to find the right person to implement that for you. I joke and give tell the story that I've got a couple of daughters that would pull the plug if I were just getting my teeth cleaned. And then I have a couple of sons that I think would find it very difficult, just very soft-hearted, sweet kids. And I just think that would be hard for them. So you're not doing a favor to anyone if this is something that's really difficult for them, to name them as the power of attorney who's going to, implement your decision. So line that up. Make sure you've got the right person doing the right thing. It's a similar issue with a financial power of attorney. Some people are just not that good with finances. Lovely, wonderful people, but maybe you shouldn't put them in that situation. So that's something to think through. A second thing with a healthcare power of attorney and the living will is have this discussion with your people. If it's your family that is the support group and they're the ones that are going to step in and be making those decisions, have this conversation. Talk to them, help them to understand, here's my decision and here's why I want it. Like I said, so many people in these parts of the country just, it's been a good go. Time for me to leave the planet, and I'm good with that. Well, help the kids understand that. Don't just say unplug me. Help them to, listen. It was a good run. I had a great life. You know what? I had great kids. I hate to leave you, but it's time to go. If it's a religious situation, say, listen, I'll be waiting for you on the other side. But, if we get to this, please just let me go. I had a situation where a lady was the healthcare power of attorney. Mom left very explicit instructions as far as pulling the plug when the time came. Sister was out of the country. Mom had an event. She was in a very bad situation, and consulting with the doctor, she was terminal. She was not going to last, and it came down to deciding whether or not she should keep her plugged in till her sister got home, keep her plugged in till she could talk to her sister. Well, her sister wasn't slated to be back for some time. This was before cell phones, so getting hold of her was not easy. So she made the difficult decision to go ahead and pull the plug. Her sister got home and was furious with her, called her a murderer. You murdered our mother for years. Wouldn't talk to her and just, kept saying, you murdered our mother. Talk to the family, have this conversation, help them to know what it is that you want. And if you've got one of the kids that you think would follow the instructions because you said this is what you wanted, give them the ammunition. Tell them, yeah, this is what I want to do, and let the other kids know. I've talked about it too much, but yes, do that. Now, does a hospital have to honor your living will, your wishes to be disconnected? Do they have to honor that? Well, that's a really good question. The attorney in me is like, well, I don't suppose they have to. But why wouldn't they? Well, I suppose there's a number of reasons. Doctors are not trained to, help people die. Although we're getting better at understanding that concept, but for the longest time their Hippocratic oath was not, help people die. So I've had a couple of clients that said, listen, I want to be unplugged. I don't want the hospital to be futzing around with this. I want it done, and I want out of there. So we actually did put into their trust and said, if the hospital is in violation of my living will instructions, and are keeping me plugged in, I am instructing the trustee to not pay their bill. Now, it turns out we didn't have to find out whether or not that worked. But hey, it's an interesting argument. All right. So when does a power of attorney end, whether it's financial or whether it's health? Now, we talked about getting rid of one, but if we didn't get rid of one, when does it end? Well, if you put a date on the power of attorney and say, I want it to end, on my 99th birthday, and you turn 99, then it doesn't work. What if you, and if it's still around and you die, then it terminates when you do. I get that sometimes. I'll get a family in and one of the kids say, we're doing, mom's passed away, and they've come in to, to figure out what the next steps are. And invariably I get one of the kids to say, well, I'm her power of attorney. Well, after she's dead, the power of attorney doesn't work. So that it'll end then. What if you've chosen one person to be your power of attorney and they resign and there's no backup? Well, then it terminates then, or that person predeceases you, then it will terminate. Court has pretty broad powers over a power of attorney if it is shown that if the agent has violated their duties under the power of attorney. And as we said before, a non-durable power of attorney that terminates at your incapacity, at the moment in time when you no longer have the cognitive ability to make those important decisions. Then if you didn't make it durable, then the power of attorney terminates. Now, I told you before, why would you do that? You know what? There are some situations that I could come up with where somebody says, you know what? I don't trust my power of attorney, and if I'm not capable of reviewing what they're doing, I don't want them to be my agent. So what then is the option? What is the option if they do that? Well, let me go one more step. Those of you that are still hanging around, let's go one more step and talk about a third segment tonight. And that is, if I didn't do a power of attorney, why would I do one? Why don't I just see what happens? Maybe I'll just die. What are the options? What if something happens to me and I'm incapacitated? What do we do then? And I call this the default plan, or the terminology is, this is the court's plan for me, or the state's plan for me. So some people, I just refuse to give anybody that much power. And as it turns out, a whole lot of people for a long time didn't do this. So the state legislature came up with something. In ways, it's not perfect, but it's better than nothing. And we call that the guardianship or the conservatorship process. And what do we mean by that? Well, a guardianship is the person who makes, a guardian is appointed, and that's the person who makes decisions concerning your personal care. That could be medical care, health care, in-home care, those types of things. Conservator, on the other hand, is the person appointed to manage your financial assets, okay? So if you don't do a healthcare power of attorney, then we'll seek a guardian. If you didn't do a financial power of attorney, we'll seek a conservator. So what's the downside? Why don't we just do that? Well, it's quite a process, and it takes some time, and it usually costs a lot of money. Any person can apply on your behalf. Once we file the application, then the court appoints an attorney who represents me very personally. Then there's an independent evaluation done by a person who's called the court-appointed visitor. And then we'll put on a case, all right? This will be a court case, not quite a lawsuit the way we think of those, but it is a court proceeding. The court can look at any document that you've provided or that they could provide to show who you would like to have serve as your guardian or your conservator. But in the end, that's only a suggestion. The court is the one that makes the determination of what's in your best interest. So we'll have a bunch of preliminary work, and then we'll notice up a hearing. And then if you don't like it, you hire an attorney who comes in and fights it and says, I don't want to be incapacitated, or I don't want so-and-so to be my conservator. And so this can be a bit contentious. For me, it's just really sad because you're gonna bring mom or dad in, and then you're gonna have a doctor who's gonna explain in detail why they're incapacitated. And that's, to me, that's just not a lot of fun. I'd rather that you do the preliminary work and have a power of attorney in place. Once the guardian or the conservator, and sometimes it's the same person, and often you do these together, that person is subject to the continuing jurisdiction of the court. So what does that mean? Well, they're going to file annual reports. And so each year they're going to file on the anniversary date of the judge signing the order. They're going to file an annual report. And in the report, they're going to talk about your health, your living conditions, what's going on there. Finances, what's happening on the finances. You know, we had so much in assets when you were appointed. We've got so much coming in, but here are the expenses for the year. Yeah, and this isn't necessarily all bad. Don't get me wrong on this. But to make decisions then, almost every time you're going to go back into the court, especially if the family doesn't, if everybody in the family doesn't agree, they're not all on the same page. Then you're going to notice up a hearing, you're going to provide, a legal filing, explain to the judge what's going on, you're going to put in some affidavits from the doctors or whatever, you're going to say, Judge, we need to make this decision, and here's what we want to do, and no, the family isn't on board. Well, then those family members are going to go get an attorney, and they're going to come back and say, Judge, no, we don't want that to happen. And so then the judge makes that decision. Well, this is expensive. It's just a layer, an administrative layer, and an added layer of cost on top of everything else that's going on. So this can be really contentious. It can be expensive. It can be time consuming, and it can just be downright sad. Again, an argument that if you've got the people that can do this, maybe a power of attorney for healthcare or a financial power of attorney may be a better way to do that. So the guardians and conservators have to follow the provisions of state law or get an order of the court. And if there's any question, I promise you they will go get an order of the court. Every time, because their backside's hanging out a little bit, and one way to make sure that they're not at risk is to get the judge to sign off on it. So can they just follow the personal instructions of the ward? Well, often they can, but if the ward has some pretty funky stuff, they're going to go back to the court to get permission to do that. Can the guardian make end-of-life decisions for the ward? And the answer is sort of. Again, you're going to probably end up in front of the judge over at court. You're going to, during the era of COVID, it's done by Zoom like we're doing tonight, but we're going to be in front of the judge. And we're going to put on some evidence to say this is what the ward wanted, this is what the ward had in mind, and then maybe you put on, some testimony from some of the kids who say, yeah, I was with dad. Dad said that when this happened, he just didn't want to be here anymore, blah, 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 blah. And if it's contested, then some of the other kids will come back and say, you're trying to murder my dad. Okay, it's not a huge exaggeration, maybe a little bit. So those are some limitations, and why it becomes, somewhat complicated, and why it can be expensive, and how it can really set, a family into a contentious situation where they end up not really, getting along well. And most of the parents that I work with don't want that. I swear there are a few that do, but most don't. They don't want to see the family, fighting. So some concepts then, some ideas on how to decide, well, should I just do a power of attorney or should I just blow it off and wait? Okay, so this is how I make a living. I advise people. I give them my best counsel. I provide that kind of planning. I don't think it's ever worth waiting. That's just my humble opinion. But if you're hung up on which one to do, then here's a couple of things to think about. Guardianships, conservatorships involve the court. Powers of attorney, no court process involved. Guardianships, conservatorships, there's a possible third party. Somebody shows up and says, no, I'm objecting to this. Dad didn't really want this, so I don't want it. If you've put together your powers of attorney and done your planning, doesn't matter what they think. Guardianships and conservatorships. Now you're thinking, well, they've got to be private proceedings. Well, they're fairly private. But if someone knows what they are doing, they can get access to quite a bit of information. They can at least determine that there was a conservatorship or a guardianship that was initiated. Powers of attorney, very private, not public at all. Guardianships, conservatorships governed by state law. Orders of the court, continuing jurisdiction of the court, powers of attorney, not necessarily. Now, I'm going to say this, and you're going to go, wait, you can't have it both ways. Sometimes one of the reasons for doing the public way, and I've seen this, is especially if there's a larger estate, then the person who's making those decisions has a record, and they can have the judge make those decisions and they can protect their backside. If they're using the power of attorney, most people don't do a good job of accounting to their siblings and letting them know what's going on. But boy, if they can, send out an email or call them up and say, hey, listen, this expense has come up, and so this is what I'm doing. That's much easier than going to the court every time. Now, annual reporting requirements for guardianships and conservatorships, that in and of itself isn't necessarily a bad thing. It's increased costs and time. And so generally it's not thrilling to do that. There is no reporting requirement with the power of attorney. And again, many situations, that's fine. Family, the kids talk to each other. Everybody knows what's going on. Perfect. I love it. I encourage it. But if they're not doing a good job with that, I'm involved in a case where the one sibling is not doing any of that, and his sisters are sitting there going, well, wait a minute, so what's really going on? And it's been hard to get that information from him. So we ended up in court anyway, even though we did the power of attorney. But as many of these as we've done, I got to tell you, 98% of it, of the time, it goes very well with the power of attorney. We've had a couple that didn't work well, So what does that mean? If you want to do the power of attorney, and I still think that's a great recommendation, you shoshould do that. You should have that so people can jump in and take care of decisions and manage your assets for you, make some healthcare decisions. I think you should do that. Make sure you do your homework up front, you get the right person involved, and then you talk to people, communicate. We do a thing called a family meeting when we've done some estate planning. We bring the family in. We walk through. This is all that we've put together. This is what Dad wanted. So make sure everybody's on the same page. All right. Well, that's it. We've had some questions. I got noted that it's time to wrap this up. Of course, I'm going on. If you would like more information from me, here's my phone number. You can go to our website at idahoestateplanning.com. There's a number of ways to get information on that. You can sneak on there and read all that stuff. You don't have to leave your name or email address or anything like that. But if you have particular questions, be sure to give us a call. Thank you, Michelle, and the Meridian Library District. You should thank them as well for putting this on. I think it's a great service. I hope you all stay safe, stay away from the COVID, hunker down if you need to. We'll get there. We'll get out of this. Have a good evening.
Hey, Mark, let's jump in one more quick thing. August, we'll be back with trusts versus wills.
Oh, yeah, a lot of questions. People have some questions, need to understand what a will does, what a trust does. Join us. That'll be a good one.
Fourth Tuesday, 6 o'clock. See you there. Thank you, everybody. Have a great night.